you all worse? Or which class has like a better social life, better things to do? Okay, we'll do housekeeping practice tip of the day. We'll talk briefly about plagiarism. We will go over some of the hierarchy of authority questions that you did. We will talk a little bit about LexisNexis, which we'll be talking about all year. We'll talk about the reading in the Judy Fisher book. We will talk about the Brian Garner reading, and we will do a card game. So, okay, lots. Housekeeping first. I'm communicating a message by Kurt Metzmeyer, who's one of the librarians. He says he'll be offering an academic advancement program on Tuesday, August 28th, at 175 at lunchtime. So I'm passing that along.
What time is lunchtime?
12:15. I don't know if that means there will actually be lunch there.
Hopefully.
But,
No, I'm just counting.
Okay.
That's just literally where I was.
Oh, I see. You looked like you were puzzling.
Nope.
What's up?
We need a smaller seating.
Why is this thing always so hard?
So, okay. Can you pass out the homework? That would be great. Just pass it. Just pass it like each. You do both. So this is in the syllabus and also mentioned last class and every class. If you don't have the hard copy, it's not the end of the world. Just print it up after class and drop it in the box by my office.
Yeah.
Also, a couple people sent the homework to the Louisville email address. All homework goes to the Gmail address. So homework for next class, you guys can just pass it up. You don't have to I feel bad that you collect everyone.
I didn't know they were passing to this one. I figured not go all the way around.
Yeah, that makes sense.
There you go.
Thanks. We'll get better. It's better with practice. Before the learning skill, I'll pass it on that. So for Wednesday's class, just read Brian Garner, section 9. It's probably the lightest homework assignment I will give all semester. So don't get used to it, but enjoy it while it lasts. Let's see. Okay, and then the last housekeeping thing is there's going to be a guest speaker on October 9th. So I know that's like a long ways out, but I'm giving you a heads up now because, first of all, he's going to be fantastic. I'm just more excited about this guest speaker. Anybody we're bringing in all year. I'm hosting him, and his name's Steve Laddick. He writes about national security law. More than that, he's like energetic and funny, and he's great. He does a podcast I listen to every week, and he and another professor are kind of like an odd couple, and they do a whole routine about the law. It's great. So I'm very excited. Why am I telling you? First of all, like I said, it's great. Second of all, like I said, there's going to be food, and it's going to be great food because I'm in charge of the food, crappy food. So it's going to be really good food. And then number 3, I'm going to give you extra credit for going. So you'll get a half grade bump up for your final grade of the semester if you go to this. So everyone should go.
What day was that again?
October 9th at noon.
That's awesome.
Yeah, I really do.
Yeah.
There are lots of reasons.
Yeah, it is, but go to that, guys.
Really great bump.
Yes.
Yeah, I did something like that. It was pretty cool.
You did. I was out of town, so
No.
then I misunderstood.
Oh my gosh. I used to watch the Rachel Dead Holiday.
October 9th. Where at 12. I think room 77. Make sure. Let's walk. Where's the Speak 75?
It'll be in the Cox Lounge.
See, I was way off. We would have been in the basement.
Yep, good question. The speech will be in the Cox Lounge. You might need to bring a chair. Kind of. I would love to just pack the room. Have a great turnout. Make a good impression on our speaker, but also I think the speaker will have something useful to say. It will not be a waste of your time. Yeah.
What's this podcast?
It's called National Security Law. It's a really poorly named podcast because it's so bland. But he's at the University of Texas Law School, and he's liberal. Another professor who's conservative is also at Texas, and they do this podcast every week about national security law. They always end with 5 or 10 minutes of what they call frivolity, the frivolity segment, where they debate movies or debate baseball or something like that. That's always my favorite part, but I love the podcast. I love the podcast. The dean is maybe more than you, more details than you're interested in, but I'll just share. The dean did a really cool thing when he got hired. He negotiated with the university administration for some funds to bring in speakers like this, in particular to help junior faculty like me develop get mentors and get advice and learn from people and broaden our perspectives and improve our research and my writing, my scholarship. But also to kind of bring some big names to the school and elevate the school status and improve the school's reputation within the wider legal academy. Because if this goes well, Steve Vladeck will go back to Texas and he'll tell all the people there that the food was great, the people were great, the students were great, everyone was enthusiastic. Louisville's a great city. I'm going to take him to the Bats Museum. It's going to be great. It's going to be great visit. So it has lots of different purposes, and it was kind of the dean's idea. So I'm really excited about it. Okay, let's shut the door. I think unless it gets too hot. If it gets too hot, just tell me.
It's already, no.
Okay, practice tip of the day. Avoid plagiarism by quoting while you take notes. So, avoid plagiarism by quoting while you take notes. Some people, when they're doing their research and they take notes, they just paraphrase as they go. So they're reading stuff and then they're taking notes and they're paraphrasing. And that's fine if you can pull that off. But to me, when I'm doing that takes too much work, and I run the risk that my paraphrasing will be too similar to the original source. So I quote the original source in my notes, and the key is, when you do this, you have to put quote marks around it so you don't forget later on that it's not your words. But that way, all my notes, I know what the original source said, and then when I go and translate those notes into an article or a brief or whatever it is, I can be very deliberate in terms of making sure I'm putting this in my own words and things like that. So my advice when you're taking notes from a case, copy and paste, and just be sure you put quote marks around it in your notes, and that is a good check. Against accidental plagiarism. Of course, you would still purposefully plagiarize after that, but hopefully no one would do that. Okay, so I have been asked by the administration every year to read 5 things about plagiarism, which hopefully you already know. But I know you had plagiarism stuff in orientation. You read plagiarism stuff today. Last year, I'll say, the school had no plagiarism allegations. So that was the first in a while. So it's a good thing. Maybe it means we're doing a better job of explaining what plagiarism is. Maybe it's just a coincidence. Okay, number 1, you're prohibited from plagiarizing, even on a draft. Number 2, not putting quote marks around direct quotes is plagiarism, even if you cite to a source. Number 3, you can't use an article and then reword the sentences, and then use the footnotes in the exact order, and then not cite that article. Does that make sense? So you can't just read somebody else's article, and then basically make each of your sentences exactly what their sentences say, but just change a word here or there. That doesn't work, okay? So don't do exactly what I just said. Don't find an article and then use the same sentence structure as the original did with changing some words and citing the original same sources in the same order, but nowhere in there mention the original article. That's bad, right? Number 4, cutting and pasting without quotation marks is not allowed, and you are running a real risk if you do that with the intention of going back to clean it up. I had a student my first year who turned in the brief, which is kind of 100% of your second semester grade, a day late, which is an automatic full 1 grade deduction. So it's like, why? And he said, I wanted to take the time to make sure that I hadn't plagiarized. So like, okay, yes, it is better than failing, but like turning this in late is better than failing. It's better than plagiarizing, but how about you like make sure you don't plagiarize the day before it's due, the day after it's due. Okay, rushing or not having time to go back and format it is not a defense to plagiarism. Okay. So you read the exercises on Judy Fisher 8. You didn't have to actually write out the answers. Bless you. Just so we're all on the same page, and then we can move on to things that law students should not already know. A, B, C, D. Only D is okay. A is plagiarism, B is plagiarism, C is plagiarism. So, if that was not clear, it's okay. It's not like your fault that it wasn't clear. But come talk to me in office hours, and let's talk about why it's plagiarism, so we make sure that you don't do it. But
Okay, so when you do the quotations, like say, since they changed up the sentence, do they still quote or they just stop?
you don't do quotation marks unless it's an exact quote.
Okay.
But you also should not just change a word or two here or there, leave out the quotation marks in sight, because that leaves the reader with a misimpression that that wording is your wording, and really it's 99.9% someone else's wording. Make sense?
Mm-hmm.
Okay. I don't mean to chill questions about plagiarism. Like, you can ask now, or you can ask office hours. Like, I'm happy to talk about it. I understand that, like, the rules weren't always clear until you got to law school. So this is not like a judgment thing against you. But I don't want to, like, keep beating a dead horse if everybody's on the same page. Okay. Let's do some review of hierarchy of authorities, and then we'll talk about the homework that you did, and we'll go over it. So if you flip to Judy Fisher, page 27. I'll just run through what this hypothetical is, and then we'll look at each of the 5 cases and talk about where they fit in the hierarchy of authority. So a woman was sleeping on a park bench. A man she didn't know came up and kissed her. She wants to know if the facts will support a claim for assault in that state, Franklin, big state. You're planning to file in Franklin State Court. In many jurisdictions, the tort of battery means an intentional, harmful, or offensive touching of another. By contrast, the tort of assault means the defendant intentionally places the plaintiff in reasonable apprehension of a harmful or offensive touching. Okay, so you're considering the following cases. Bailey. Let's take a look at number 1. You're a lawyer, you come across the Franklin Supreme Court case, and in that case, a woman was sleeping on a park bench when a strange man came up and kissed her. The issue in the case was this battery, and the holding was yes. So, first, do you think that case is on point with our case?
No.
No. You know, it's not like 0% on point. It does like have to do with some with similar fact patterns, but it's not 100% on point because we're trying to figure out whether or not our client can bring an assault claim, and this is talking about whether the client can bring a battery claim. So, good job, Bailey. Not on point. Emily. Light here. Franklin Supreme Court case, a woman was sitting awake on a bus bench when a strange man came up and kissed her. The issue was this assault. Holding, yes, it was assault. So, on point?
This one was a wave, no.
Correct, not 100% on point. You know, not 0% on point because our client wants to bring an assault claim, this is an assault claim, you know, somewhat similar fact pattern, but an important difference in the fact pattern means that it's not 100% on point. A legally significant difference means that it's not 100% on point. Let's see, Zach. Number 3, Franklin Court of Appeals case, a woman was unconscious on a bus bench when a strange man came up and kissed her. The issue, was this assault? The holding, no, it was not assault. Is that on point?
Yep.
Okay, so we finally have a case that's on point. Is it a controlling authority? Remember, we are suing in Franklin State Trial Court, and this is a Franklin State Court of Appeals case.
Would be controlling.
It's controlling. In the hierarchy of authority, the Court of Appeals is higher than the trial court. So on point case, 100% on point really, and a controlling authority, that's the end of the game. I mean, as long as it hasn't been overturned or a statute has repealed or something like that, like we now know our answer to the legal question. But let's do 4 and 5 and make sure that it doesn't change the equation at all. Let's see, Sydney. New York case, a woman was sleeping on a park bench when a strange man came up and kissed her. The issue, was this assault? Holding, no. So is that on point?
No.
Why not?
It's in New York.
So you are correctly saying whether it is a controlling authority,
I
but
thought it had to be controlling. Well, I don't know.
that's okay, because someone else is probably thinking the same thing. The question of whether it's on point is whether it's addressing the same legal question as our case. The question of whether it's a controlling authority has to do with like what jurisdiction and things like that. And then, this is where the like terminology gets confusing, whether or not that case controls ours requires it to be a controlling authority and for it to be on point.
Okay, that's what I was confused on. Then-
So is it on point?
Yes.
It's on point because it's exact same legal question, but as Sydney's pointing out, it's not a controlling authority and therefore it is not going to control our case. All right, federal court case number 5, McKellar. Federal court case from Central District of Franklin. A woman was sleeping on a bench in a shopping mall. A strange man came up and kissed her. Issue, was this assault? Holding, no. So on point or not on point?
Yes, it's on point.
On point. Tell us why. That's right.
The fact pattern is the same.
Yeah. No. The fact pattern and the legal question is the same. So and what I mean by that is it assault when someone kisses a sleeping person?
Okay.
This says no. Our case raises the question, is it assault when someone kisses a sleeping person? So, exact same legal question. So, McKellar correctly says that it is on point. Is it a controlling authority?
No.
No, that's correct. And why not? You seem skeptical, but you're right.
Well, because it's confusing, but it's federal court.
Yep.
Meaning it's not at the state level, so they don't necessarily have to follow it.
That is exactly right. Because assault is a question of state law. The state court does not have to follow what the federal court says state law means. Okay? Yeah.
But you would mark that as persuasive,
Yep.
right? Okay.
Yep.
Just making sure I get it right.
Exactly. Last question, assuming there are no other relevant authorities, will the client's facts support a claim for assault? Alex, what do you think?
Yes, because it's the Supreme Court. It's still number 2 is holding yes for that for assault.
So was number 2 on point or not on point?
The no, because the Franklin Court of Appeals case says no, and then that's the most
Right, but
controlling one.
so you're correct. There's not a the client's facts do not support a claim for assault. But let's walk through why number 2, the Franklin Supreme Court case, does not mean something different. What's the difference between that case and our facts?
She's awake.
She's
So
awake.
it's a different legal question.
Yep. So there's only one case on here that is on point and a controlling authority. That's number 3, and so that provides us our answer. So let's take a look at 28 and 29, the homework that you did. And let's, yeah.
I actually had a question about the fifth one. The fifth source, would the fact that the bench is in the shopping mall change anything?
Why is that? Why is that?
Because it could be for private property, and the other, in the claim was that it was a park bench on public property. I don't know.
Yeah, so this, I mean, I think the question you're raising is really good to keep in mind for all the cases that you'll read in this class. Every case is gonna have some different facts. The question is, are those facts legally significant? And so sometimes they are, sometimes they aren't. In this case, is it legally significant that one person is is at a mall and one person is at a park? The short answer is no, but the longer answer is you would want to study what the elements of assault are and see, like, okay, let's say there are 4 elements of assault. Do any of those elements hinge on the location of the tort? And they don't. But you know, it's a good line of inquiry. Okay, hierarchy of authority. Dimitri, let's start with
Right there.
Yeah, that's all.
the first question. Under number 1, State of Columbia questions. Which did you think were primary authorities?
I thought.
I guess maybe I should have asked all these before you turned in your homework, but
Yeah, that would have helped me.
remember.
Let's see. So, all right, this one right here.
Yeah, so State of Columbia, and then it says which are primary authority.
Okay. Oh, I thought Columbia Supreme Court was primary, and then the other 2 were. Oh no, and I thought Illinois State, because courts did it, primary.
Great. So in each case, the government did it. A, the government institution is a court. B, the government institution is the legislature. Both of those are primary authorities. That means that the law review article, it's not primary authority, it's secondary authority. Let's see. Shelby Hall. Which are mandatory authority, which is just another way of saying controlling authority.
The Columbia Supreme Court.
Yep, exactly. It's a controlling authority because we are in Columbia State Trial Court and Columbia Supreme Court is higher. So that's controlling authority, and the other 2 are going to be persuasive authority. They are persuasive authority in the case of Illinois because we're not in the jurisdiction of Illinois. Illinois statutes do not control, can never control what the law is in Franklin. Columbia, who cares, whatever. And then the law review article is a secondary authority. Secondary authorities are never controlling mandatory authorities. Okay, which are on point? Bryce. Which are,
He's not here.
oh, he's not here. Kelsey?
The one
Okay,
that's,
which of them are on point?
I don't think that any of them are on point, because isn't she trying to get this for her son, right? Or was it-
She does want her son to be able to bring a
review.
consortium claim.
Yeah.
And so you're right that, let's walk through each one. You're right that A is not on point, the Columbia Supreme Court case, because that's talking about consortium claim from a spouse suing for the loss of another spouse.
Mhm.
B is also talking about a spouse suing for loss of a spouse. But C is talking about children suing for the loss of a parent. In our case, is children suing for loss of a parent. So is C on point?
Yeah.
Yeah, it is on point. Now, it's not a controlling authority, so it's not gonna answer, our questions. It's not gonna control our case. But just like we talked about last class, don't confuse the question of whether something's on point or not on point with the question of whether it's a controlling authority or persuasive authority.
So the last class we talked about like a timeline or
A spectrum
Yes,
for on
a
point,
spectrum.
yeah.
Could the fact that it talked about just the consortium at all, put it on a spectrum?
Yep, absolutely. I'd say if it's talking about a consortium claim at all, then it's not 0% on point. It's not on point. It's not entirely not on point. But unless it's talking about a consortium claim for a child suing for the loss of a parent, it's not 100% on point. And it's not gonna be definitely controlling unless it's a controlling authority that's 100% on point. Okay. So a good claim or not a good claim? What do you think? What do you think, Shalia?
It's not a good claim
I think that's right. Tell us why.
because only the law review article is on point and it doesn't matter
Yeah.
because it's secondary, and the other two, even though they're primary authority, they're not on point.
I think that's right. It's a little bit unclear because none of the authorities absolutely expressly foreclose a consortium claim by a child for loss of a parent. But we learned from the intro that the evolution of these claims starts with the spouse, and kind of the extension to a kid is an extension. And so if a court hasn't gone that far, it's unlikely that the court is going to go that far. Okay, good. Questions on that? Yeah.
As far as the one with the law school article, that would not be considered persuasive, correct?
Well, it is a persuasive authority, but that does not mean that it is going to definitively persuade the court to do what the law review article says.
Is everything that's secondary by default persuasive?
Yes.
Okay.
Yes.
Does this mean that this is not a case that we should take?
I mean, that's a good question. I think partly probably depends on how much you're getting paid to take it. I won't forget you, but I'll come back. So let's go through each of the three again. The Columbia case, controlling authority, says a spouse has no claim for the loss of another spouse's consortium. That's a big problem for bringing this claim because, like I was talking about with Sharia, the evolution usually starts with, okay, first a spouse can sue for a loss of a spouse. And then if a court is willing to go that far, a court will maybe sometimes let a child sue for the loss of a parent. So if a court hasn't even taken the first step, it seems unlikely that Columbia is going to be willing to take the second step. But, look, if a client came to me and said, I will pay you $1,000 an hour to file this suit, I would tell the client, our chances are unlikely, so I'm not going to take your money unless you full disclosure here. But I am willing to file it because this is not a claim that is expressly foreclosed by a controlling authority. No controlling authority in Columbia has said children cannot sue for the loss of a parent. So, I'm not going to be sanctioned as an attorney for bringing this, and I'm not going to totally embarrass myself with the court by bringing this. So if you want to pay me to bring this, I'll bring this. If a client came and said, I don't have any money, but I'll give you a third of what we win if you bring this, I would probably say I can't do that because a third of nothing is going to be nothing, and I have to pay my electric bill.
I guess I just think, so you said, basically, being able to sue for the loss of the spouse, that comes first. I was almost thinking of it the other way around, it just hasn't happened yet that someone from a controlling authority, or has gone there to a controlling authority and taken this case ever. But I would think that you'd be more likely to win if it was a child who completely depends on a parent for their emotional needs and just the basic needs. But
Those are all the arguments that you would want to make when you bring your claim. And really you would just file a complaint without a lot of argument in it. And then the defendant would file a motion to dismiss. And then in your response you would make all the policy arguments that you're making. They're certainly there's some sound policy behind your policy arguments. Yeah.
I guess when it comes to the persuasive authority thing, I keep getting myself confused, so I'm probably gonna confuse everybody else too.
No, they're probably already confused, so
But in order for it to be persuasive, does it have to persuade on your side of the case?
Nope.
So it can still be persuasive even though it's bad for you?
Yeah, don't be confused by the word persuasive
Okay.
and thinking of it in kind of a literal sense. For our purposes, persuasive just means it's not a controlling authority.
Okay.
And really, if I could get in a time machine and go back and change the way some legal terminology came about, I would just abolish the term persuasive authority, and I would say controlling authority, non-controlling authority.
Okay.
But instead, we're left with controlling authority, persuasive authority, even though that persuasive authority often does not persuade. And sometimes doesn't persuade in our direction. I persuade the wrong way. Make sense?
Yeah.
Okay.
I think I did it right, but.
It's all right. Well, it matters a lot more that we're all on the same page now going forward, which is why we're talking about these in class, than whether you got the homework right.
Just real quick, going off that, so like for like this assignment, say that there was another case in there that was pretty random and like barely applied at all to this, that's still persuasive.
What do you mean pretty random?
Like maybe it talked about like a child suing for something else because of the loss of his parent or something. So it was still like child, loss of parent, but like wasn't consortium. I don't know. It was like
Okay.
something random. Would you still count that as a persuasive case, or if it's so off the wall, is it just nothing? Like trash it?
Don't be confused between whether a case is on point and whether a case is controlling or persuasive. Because what you're talking about is a case that's not very on point. And that doesn't inform the question of whether it's a controlling authority or a non-controlling authority.
Right.
So let's take your example. There's some kid who sues on a non-consortium claim. The facts involve the death of a parent. So let me just give you an example. Let's say that the parent buys a toaster. The toaster explodes and kills the parent. And the kid is like, I'm gonna sue the toaster company for a defective product. Okay, so far so good. So whether that is on point with his consortium claim is one totally separate question. And by the way, is it on point? No, not on point because we're bringing a consortium claim and it's talking about a different legal claim, defective product claim. So that's point number one. Is it on point? No, it's not on point. And then the second claim, the second question is it controlling authority or is it a non-controlling authority? Non-controlling means persuasive. And the answer to that is, well, it depends on what court decided it. So if it's the Franklin's Supreme Court that decided that case, the toaster case, then when we sue in Franklin State Court, we can look to that case, we'll say that's a controlling authority on our lower court. But it's not gonna help us much because.
So if it's a law journal and it said that same stuff, it's still persuasive even though
Yep.
it would have no value.
Exactly. Persuasive does not mean valuable. It just means not controlling authority. Good question.
All right, so, what was I gonna say now? Oh, so when we get asked controlling and on point, so if we're asked on point, that means controlling because it's on point, like, or controlling or persuasive because it's on point. And then if we're asked controlling, you just want us to say like, is this a controlling court?
So if I say, is it a controlling authority?
Yeah, okay. But because in the homework, I think it just said controlling, and I'm like, controlling on point or controlling authority?
Yeah.
I think I went by controlling authority, and then when you asked on point, I did
That's
controlling
good.
on point.
That was what the homework was asking. But again, I care much less about whether you got the homework questions correct than I care that, like, by the end of the semester, we all understand how the hierarchy of authority works and how law works.
Yeah.
So let's make sure we get that. I think you did. It sounds like you did the homework right.
Oh,
But is something a controlling authority or not? That depends on which court. Also, like which statute, which jurisdiction.
so say it was Illinois, right? But we're in Kentucky.
Yep.
Illinois Supreme Court. So they're controlling, but not for our case, right? So now,
If you're in Kentucky
They're
and you're
just
talking about
persuasive?
something in Illinois,
then it's not. Then it's persuasive.
that's correct.
Okay. But that court does control stuff in their state.
Exactly.
Okay.
On point. Okay. And controlling authority versus persuasive, just talking about which court, which jurisdiction we're in, whether it's on point, are we talking about the same legal question? So imagine controlling, I'm gonna say, just to avoid confusion, non-controlling, persuasive, those mean the same thing. And then imagine this, on point, not on point. You can fit this question does not affect this question, and this question does not affect this question. So let's just go through an example of each one. We're going to sue in Kentucky State Trial Court. We're going to sue for the loss of consortium, child suing for loss of a parent. Okay, so that's our claim. Kentucky State Trial Court, child suing for loss of parent consortium. Imagine that there's a Kentucky State Supreme Court case that says a child can sue for loss of a parent. That is on point because it's exactly the same legal question, and it's controlling authority because it comes from the Kentucky State Supreme Court. Now let's imagine that there's a case in Indiana State Supreme Court that says a child can sue for loss of a parent. It's on point because it's our legal question, but it's non-controlling because it's out of Indiana. Now let's imagine that there's a claim for adverse possession where I've lived on property for a long time, and I say now it's mine, even though it wasn't mine originally. And it's coming from the Kentucky State Supreme Court. The case is about adverse possession. It's coming from the Kentucky State Supreme Court. And we are lawyers bringing a consortium claim in Kentucky. Not at all on point, not even close. But it is a controlling authority because Kentucky State Supreme Court is a controlling authority over Kentucky State Trial Courts. And now let's imagine that there's this adverse possession claim from an Indiana State Supreme Court. It's not at all on point, and it's not a controlling authority. It's not persuasive. Now, a third question, and really kind of the ultimate question, is which of these cases controls our particular case? Not which of them is a controlling authority, but which of them is going to control the outcome of our case. And in order to do that, you got to hit that trifecta that we talked about last time. Okay? First of all, it has to be a holding in order for it to control our case. The previous precedent, we have to be talking about a holding from that case. I assume for the sake of this class that everything was a holding. Okay? Secondly, it has to come from a controlling authority. And third, it has to be on point. So only one of those four cases, only one of those four precedents that I just described controls the outcome of our case. Even though two of them are controlling authority, and even though two of them are on point. Only one of them is both a controlling authority and on point, so only one of them is going to control the outcome of our case. Clearer? Not clearer? Yeah. Bailey
So
and
is
then Mitchell.
controlling authority and primary authority kind of the same thing?
Nope, that's a different thing.
Okay.
So, primary, secondary, and controlling, non-controlling / persuasive. A controlling authority is an authority that has the power to tell a lower court what to do. That's what a controlling authority is. Okay? A non-controlling or persuasive authority does not have the power to tell a lower court what to do. So, Indiana is not a controlling authority over Kentucky. Sorry, not a controlling authority over Kentucky. Primary versus secondary. A primary authority is something that the government does.
Okay.
So the Indiana State Supreme Court is a primary authority because that's a government court, but it's not controlling. It's a merely persuasive authority. Kentucky Supreme Court, primary because it's a court, controlling because we're in Kentucky. Secondary sources is the non-government stuff.
Okay.
Law review articles, things like that. Always non-controlling. Okay. Yeah.
This is kind of jumping ahead, so I don't know if you want to talk about it yet. It's
Sorry.
in problem number 2. But, so you said all of those were holdings up there, and like in F in problem number 2, they hold that a lot could recover. But then they add something down there about, like a child doing so. So that
Yep.
addition is not, controlling,
Yeah.
it's just an addition.
So let's talk about that specifically right now, just so I can be responsive to that and make sure we're all on the same page, and then we'll walk through and we'll talk about kind of the second part of your question. So everybody look on page 29. This is letter F. It describes the Franklin Appellate Court case. The holding of that case is that a wife can recover for loss of her husband's consortium. A wife can recover for loss of her husband. That's the holding. And what does it mean to say that's the holding? Well, it means that in that case, there was a wife suing for the loss of her husband. And the court said, you win. Or you can win if you prove the right facts. So the court had to say that in order for the outcome of that case to be what the outcome of that case was. That's what makes it a holding. Then the court added, although the question is not before us today, we take this opportunity to state that allowing a parent to recover for loss of a child's consortium is similarly consistent with sound principles. That's not the holding, because the court didn't have to say that. That question was not before the court that day. The court could have still reached the same outcome it reached without saying that. So it's not a holding. If something's not a holding, it's dictum. And so what's the difference? What is the effect of a holding versus the effect of dicta? Just like Bailey's talking about, a holding has the potential to control future stuff. A dicta never has the potential to control future stuff. At least as a formal matter, never has the potential to control future stuff.
So that statement would be secondary authority and persuasive authority, or controlling authority, but this statement is?
It would be over here. Primary authority, but non-persuasive.
Okay.
Primary because it is coming from somebody on the court, right? So it's coming from it's a governmental voice, so it's primary, but it's non-controlling because it's dicta, not holding.
That's just the dictum though.
Yep.
So that part F is really 2 parts, so we have kind of 2 answers to that question.
Exactly. Exactly. Let's walk through all the letters, and when we get to F, we get to these questions, you'll see how it plays out. Okay, so
I don't even remember reading that part.
where's Sam? What does it say? Okay, which are the primary authorities?
All of them but the restatement, right?
That's correct. So the U.S. Supreme Court, the Franklin Supreme Court, a Franklin statute, a Franklin Supreme Court, Franklin Appellate Court, a federal district court, they're all courts or statutes. They're all instruments of the government. They're primary authorities. Only the restatement is a secondary authority. What is the restatement? It's just a bunch of lawyers got together and wrote a book about the law. Maybe they're right, maybe they're wrong, but they don't have the authority that comes, they don't have the force of government behind them. Okay, now, which of them are controlling authorities? Not to say that they're necessarily on point, but which of them are controlling authorities? So I'll walk through this question because I think just make sure we're all on the same page. A is a controlling authority with respect to whether or not it's constitutional for a state to allow a consortium claim. So if our state of Franklin wants to allow a consortium claim, we know that the U.S. Constitution allows that. And that decision by the U.S. Supreme Court about the meaning of the U.S. Constitution is controlling, because the U.S. Supreme Court is the highest authority in terms of interpreting the U.S. Constitution. It doesn't tell us whether or not we have to do a consortium claim in our state, but it does tell us the U.S. Constitution allows that. So that part of that is controlling. Now, the court said, among other things, allowing this child to recover will serve substantial justice. That's just the court, opining. That's just the court saying, we don't actually have the authority to make a state do a consortium claim, but we want you to know, we think it would be a good idea if you did. That's not a controlling authority, that's dicta. Right? That's not only holding can be controlling, so that's dicta. Okay, what is be a controlling authority? Franklin Supreme Court held that a child could recover for loss of a parent's consortium. Absolutely, that's controlling authority. We are in the Franklin trial court. That Franklin Supreme Court is controlling authority. C, Franklin statute provided all claims for loss of consortium were abolished. If that statute still existed, it would be controlling authority. But we remember last class we talked about how if that statute gets invalidated as unconstitutional, it's erased from existence. So now in 2018, we would think of this 1996 statute as neither controlling, neither persuasive. It just doesn't exist anymore. D, Franklin Supreme Court held that the statute was unconstitutional. That's a controlling authority. Franklin Supreme Court, always going to be a controlling authority. Restatement of torts, that's not a controlling authority. Secondary sources can never be controlling authorities. 2006, Franklin Appellate Court held that a wife could recover for loss of her husband's consortium. That holding is a controlling authority. Then it added this other dicta about how they think it would be a great idea to allow a child to sue. Sorry, actually they think it would be a good idea to allow a parent to sue for the loss of a child. That's dicta, that's not a controlling authority. And then 2007, you have a federal court talking about the meaning of state law. When we sue in state court, that federal court is not going to be a controlling authority.
Isn't that what A is? I thought A was persuasive for the same reason.
So A is talking about a federal court deciding the meaning of the federal constitution.
Okay, gotcha.
But let me spell out why. Even if you know, let's
No.
just.
Oh.
I was gonna spell it out, but you can spell it out. If you
Oh,
want.
no, sorry, go ahead. I thought you were asking if I wanted to as well.
And you said no, you don't want
Sorry.
to. In A, the U.S. Supreme Court is saying, yes, there's this state law in Delaware. There's also this federal constitution. And we are going to interpret the federal constitution. And we're going to decide whether the federal constitution allows that Delaware state law. And we interpret the federal constitution to allow that Delaware state law. So we have a federal court interpreting federal constitution. That part of that is controlling. It's different in 2007 with the federal district court because there, the federal district court is not examining or interpreting the federal constitution. In G, all that federal district court is doing is interpreting a state law. So there you have a federal court in G, a federal court interpreting a state law that's not controlling on state courts.
The reason that I said A was persuasive, which I know it's not now, but I remember last class about something that you said that the federal court can say, since it's a different state, that statute is constitutional, but another state doesn't have to abide by it or something.
That's right. So let's walk through what the two statements. So in 2004, the court heard a case challenging the constitutionality of a Delaware statute. Delaware statute said a child can recover for the loss of a parent. The court said, let's go straight to the holding. The statute is constitutional. What that means is the U.S. Supreme Court said that if Delaware wants to do a consortium claim, it can. It did, but the U.S. Supreme Court did not say that Delaware must. And so that means when Kentucky comes along, or Columbia, or Franklin, Kentucky has the choice. Do we want to do it or do we not want to do it?
It would still be controlled.
It's the question of whether or not Kentucky can do it. That question is controlled by this case. But the question of whether Kentucky must do it or has done it is not controlled by this case. That's still up to the state of Kentucky.
Oh.
Does that make sense?
Mm-hmm.
Okay.
So that was still not persuasive, right?
What'd you say? Which is still?
Sorry, the Supreme Court decision. Or did you say it was not persuasive or persuasive?
So controlling would be not
Yeah.
persuasive, right?
Oh, okay.
That U.S. Supreme Court case said that if a state wants to do consortium, it can.
Right.
That statement is a controlling statement.
Mm-hmm.
The U.S. Supreme Court also said, and by the way, we really think that states should do this. That is not a controlling statement.
Okay.
That is a non-controlling statement. Another word for non-controlling is persuasive. even though it might not be.
So,
Yeah.
I get that on that point.
No question?
No, I get what you're saying.
All right. This is confusing, it's new, the learning curve is steep. I guarantee you're gonna get this by the end of the semester, not because we're gonna talk about it every class, but just because you're gonna practice it and you're gonna see how it works in your other classes. So don't be, down on yourself. More importantly, don't be down on me. It'll come, but questions are good. I'm sure if you have a question, and other people have that same question.
Where would A and F be on that?
Yeah,
right there?
let's do that.
So I get what A is saying. A is saying y'all can do it, but you have the choice, right? Like we just said that you can do it.
So A says, let's just talk about the holding of A. The statute is constitutional. So A tells us that if a state wants to do a consortium claim, a state can.
Right. If we want to go to the movies, we can go, but it's up to us.
Right, exactly.
Yeah.
So that is a controlling authority, and it's on point with regard to the question of whether or not our state can do a consortium claim. So with regard to the question of whether our state can do a consortium claim, controlling on point. With regard to the question of whether or not our state has done a consortium claim, it's not on point, because it's not interpreting Kentucky law. It's not telling us what Kentucky has done. Make sense?
Yes, sir.
Okay. And actually, since it would be a federal court trying to figure out what Kentucky has done, or whether or not it has done that, it would be not on point, and it would be non-controlling. All right. Other questions? All right. Let's do, let's see what's next. Okay, I already did that. Yep. Okay, so if you, actually you don't need to pull it up, I'll pull it up. So let's imagine that this, let's imagine this happens. An attorney walks in your, a client walks in your office, you're a solo practitioner, and the attorney says this. You should take some notes, because some of this is going to come back. The client says, I used to live in California. I now live in Jeffersonville, Indiana. My favorite movie is Fast and the Furious 4, because I have terrible taste in movies. I leave a spiky club in my yard. I left a spiky club in my yard. I threw a children's birthday party in my yard. A child stepped on the club and hurt his foot. I have brown hair. I drive a Toyota. So I've just given you about 8 facts. And if it seems like some of those facts will not be legally relevant, you are right, and welcome to dealing with clients who walk in your door. I get about half of those facts are legally relevant. That will rarely happen. Usually a client will walk in your door, tell you 300 facts, 298 of them will be completely irrelevant. So, you're welcome for this. Okay, so so you start, you tell the client, okay, I'm sorry about the, I'm sorry, you're getting sued for the foot thing or whatever. And I'm not really sure whether or not the plaintiff is going to have a good claim against you. But I'll do some legal research. So you go to LexisNexis. And you wait for the internet to come on. And it finally does. So actually, I shouldn't have done that as fast as I did. You go to LexisNexis.com, so you all will eventually do this. You click on Go to Lexis Advance. And then you start searching through Lexis. We will spend the second half of this semester talking a lot about how to research and search and find cases on Lexis. But I'm going to pretend that after, a good 30 minutes of searching, we found this case. Lubitz v. Wells out of Connecticut. Hard to see. Did you all actually read this already?
Yeah.
Oh, wow. Good. All right, so you know what it's about. So you find this case, and let's walk through a little bit of a refresher, because we walked through one Lexis case already, right? Page number and things like that. Shower assistance, right?
Yeah.
Let's just see, okay, where does this opinion begin? It begins where it says opinion. And so don't be fooled, all this other stuff is not the beginning of the opinion, it's just someone on staff at Lexis who has summarized stuff for you. So this is where the actual opinion begins. And where is page 323 of the opinion begin? Phil.
I'm sorry, I don't understand the question. Where does 323 begin?
Yeah, so this case was published in this Reporter, Connecticut Supplement, volume 19, and it starts on page 322. And so if you want to cite this, you're going to need to know what page to cite to. And so let's imagine that you're citing to something at the end of the opinion. Okay. What page is that on?
323 it looks like.
Yep, and how do you know that?
Because it says in the brackets in bold.
Yep, right there, it means this is where page 323 of the opinion begins. This is where page 322 of the opinion begins. What court are we in? Superior Court of Connecticut. Usually a Superior Court, very poorly named. It actually means it's the least superior court. Usually the Supreme Court is the top, and usually Superior Court is the bottom. So that's stupid. At least in Kentucky, we don't do Superior Court, we do District Court and Circuit Court. And then Appellate Court, and then Supreme Court. Okay, so now we kind of have an idea of what this stuff is that we found on Lexis, because you will find this on Lexis, not in your casebook if you're just searching for stuff. And so then you read the case, and you all already know what happens in the case. Jay's not here, you guys. Emily, do you remember this case from?
I believe this is the golf club.
Yep. And so what? Just very broad strokes, but what happened? And it's okay if you don't remember.
So I can't remember who's who, but someone left their golf club in the yard. That person's kid and the neighboring kid played in the yard. The kid of the golf club owner picked up the golf club, and I can't remember if they threw or just hit it, but basically the other kid got hit with it.
Yep.
And so the parent of the injured kid sued.
Yep.
And the court said, golf club is not a dangerous thing, we can't sue that because otherwise it would cause too much chaos.
Great, very good memory. Unless you had torts class 5 minutes ago, you have better memory than I have. But that's all exactly right. So the key takeaway here was that a golf club was not considered an inherently dangerous item, and so therefore, there wasn't. It wasn't the end of the world for the guy to leave his golf club laying around. Okay, so that's what we learned from this case. Now, let's imagine that we found this case and we're like, oh, this is, somewhat useful for us to know because our client is going to be the defendant getting sued, and our client doesn't want to get sued successfully. And, here's a defendant who was able to fend off a lawsuit. But it's in Connecticut. So, and it's talking about Connecticut state law, and our stuff is in Indiana. So, Shelby Boyd, is it a controlling authority or is it persuasive?
No, it's persuasive.
Right. And so, we're doing our research and we're like, oh, well, I don't, I would rather know what the law is in Indiana than the law in Connecticut. Lexis can help with that. So you click on this button right there, and it will tell you every time this case has been cited. And as it happens, this case has been cited 4 times. Actually, for a case that's in your casebook, I'm surprised that it's only been cited 4 times. In any event, you find out that this case actually has been cited by the Indiana Court of Appeals, right? Because you started, okay, these are the decisions that have cited it: Connecticut Superior Court, Connecticut Superior Court, Connecticut Superior Court, and Indiana Court of Appeals. So you're like, okay, well that will be a controlling authority on my Indiana State Trial Court. So I'll go see what they had to say about Lubitz v. Wells, and it says, we note that our resolution of this question is consistent with persuasive authority from other states. Those courts have also held that a golf club is not an unreasonably dangerous instrumentality. See Lubitz. So what do we get from this? Well, here we have an Indiana court that is citing Lubitz in a favorable way. And so that is useful to us to know. Now we know that when we sue in Indiana, Lubitz is not a controlling authority, but Indiana courts have looked to it as, a good statement of the law. And we can cite to Brewster's citing to Lubitz. We can cite to Brewster and say, hey, Brewster is controlling. Brewster thought that Lubitz had a good rule, so therefore, in this state trial court, you the state trial court have to listen to what Brewster said. And since Brewster said Lubitz is good, that means you the state trial court should listen to what Lubitz said. Okay, so now let's walk through the steps that Judy Fisher gave us in terms of what's done. That's not it. That's not it. That's it. All right, so let's go through this, and then we will bring Lubitz in. Jacob is right there. Okay, so this is on page, I don't know what page. One of the pages from Judy Fisher you read. Is it 26? 31. No, it's not. Yeah, I'm going to be right. 26. Yeah.
I got it on here, but yeah, I'll look on there.
Okay, so in our Spiky Club case, Jacob, let's start by identifying the legally significant facts in our client's case. Let's go through all the facts that the client told us. You tell me if you think it's legally significant or not. The client said, I used to live in California. Legally significant? No. The client says, I live in Jeffersonville, Indiana. Legally significant? Yeah, because that's the jurisdiction it's going to control. So we need to know what jurisdiction it's going to control. Client said his favorite movie is Fast and Furious 4. No. Not legally significant. Client said I left a spiking club in my yard.
Yes.
Yep, legally significant because that's what the suit is over. Client said I threw a children's birthday party.
Yes.
Legally significant, right? That's how the kids got to the yard where the spiking club was. A child stepped on the foot and cut his foot. Legally significant. Yep, that's the injury. Client says I have brown hair.
No.
No. Client says I drive a Toyota. No. Okay, great. So we've now identified the legally significant facts. Identifying the legal issues in the client's case. I'll just tell you, he's going to get sued. He is getting sued for a tort for this person's injury. You would go through different elements of the tort. It's not classified torts. Okay? So locate cases with precedential value. What does that mean? It means you look for cases with similar facts and similar legal issues. And we found Lovitz. Somewhat similar facts in that there an object was left laying around, a kid picked it up, and an injury happened. But not exact same facts, because there's a difference between a golf club and a spiky club. Similar legal issues, very similar legal issues, because there, like, the injured kid was suing. Here, the injured kid was suing. The injured kid was suing the person who left the object laying around. Here, the injured kid is suing the person who left the object laying around. Similar legal issues. Evaluate the weight of the authorities. We've kind of done this a little bit. Lovitz is not controlling. It's a non-controlling case. Level of the deciding court. Lovitz was, what do we say, Superior Court, Connecticut, so lower, very, very low level court. Here, the decision, that really only matters if it's been like overturned or something like that, so I don't pay too much attention to that. Subsequent treatment by other courts. It's been treated favorably by a controlling court, Indiana Court of Appeals, which is going to control our Indiana State Trial Court. So it's not a controlling opinion, Lovitz, but it has been treated favorably by Indiana. Subsequent treatment has been favorable by our controlling authority. So we'll synthesize all the applicable rules of law here. Let's see. Taylor. So this is, usually the trickiest part of this. The rest is somewhat mechanical, but this involves some judgment. So you want to take a shot at explaining what the rule is that comes out of Lovitz.
That if you leave a object that is not inherently dangerous laying around and someone uses it to injure someone else, you may not necessarily be deemed as negligent.
Right. And first of all, great job. And then what is the implication of that for dangerous objects? So Lovitz talks about an object that's not inherently dangerous. Says you, the defendant, are off the hook. But do you think there's an implication for what would have happened in Lovitz if the object had been dangerous?
I think they would have been found negligent.
Yeah. I mean, why is Lovitz doing this inquiry into whether it's dangerous or not if it doesn't matter? It must matter. I mean, it's not that long an inquiry. It's like the shortest opinion I've ever seen. It's like 3 paragraphs. But 5 paragraphs maybe. But it is an inquiry, and so you can infer that the court thinks it's important that the golf club was not dangerous, and you can infer not infer. It says that, and then you can infer that the court would think if the object had been dangerous that the case comes out differently. So now, so good job, Taylor, Logan. So now let's apply the rule that Taylor explained to the facts of our case, the legally significant facts that Jacob told us about. So the rule is that if the object is dangerous, it's negligent to leave it laying around where kids will be playing. How can you apply that rule to the facts of our client's case?
He left, it is a dangerous object, and he left it in his yard, and then had children in his yard, so using the facts that you're given to me, basically, he was negligent.
Great. So, and there you just did it. You did the last thing that Logan said was number 7 on the Judy Fisher list, predicting the outcome. My prediction is you were negligent. Spiky club is dangerous. You can't leave a dangerous object laying around where you're inviting kids to play. So I predict that you were negligent. Okay. Makes sense? Yeah.
What if you had your own land and had no trespassing signs or something, and you had something dangerous out in the field, and people go and stumble upon it?
You're gonna love tours because they have case after case with this. A swimming pool and all this other stuff. There's general rules. There's exceptions to the rules. I'm not a tourist expert, so
Spiky club probably an attractive nuisance.
Zach likes.
That's not true at all.
Zach likes
I just really like that phrase.
I don't think a spiky club is an attractive
No,
nuisance.
it's not.
Because, so what's actually getting as a swimming pool is an attractive nuisance, which means that even though it's on your property, you should be worried that like people will be attracted to it, and then they'll get injured if you don't take certain steps. Spiky club, I think, not so attractive. I mean, to each his own.
Yeah,
I
I
guess.
love a spiked club. Like, more than a swimming pool, so.
If you're into that.
So good, you should go to your torts professor's office hours and ask all about these questions.
Thanks, man.
My least favorite torts case, I'll tell you this, is the guy, people kept trespassing on his property. And it was kind of like an abandoned cabin. So, arguably he didn't really have that big an interest in keeping trespassers out, but he didn't want them there. So he set up a crossbow. And I don't know if he killed or just injured the trespasser, but he shot the the automatic. He wasn't present, but the crossbow got triggered by the door or whatever, and shot the And so his argument is hey, they were where they weren't supposed to be. It said no trespassing. I warned them before that they can't trespass here, and choices have consequences. And he did not win. I think he did.
That's good. That's very telling.
I didn't know you were such a curmudgeon.
Yeah, usually it's not something like this semester. I'm on my True Stripe show Okay. All right, so we have 15 minutes. We're actually a little behind where I thought it would be, but that's in some ways a good thing because you all have been asking questions that are on your mind. I'd rather you ask them and us talk about them than you not ask them and then just remain confused. So let's talk briefly about some of the advice that Judy Fisher and Brian Garner give about how to read and write about a case. Garner talks in section 1 about how to brief a case. I think, that can be useful. I think it largely speaks for itself. I would point out that he's talking about how to brief a case for yourself, for your own purposes. He's not talking about how to describe a case in a brief that you will file with the court. Judy Fisher talks about that on page 31. So let's just take a 2-second look at page 31. And I think I have it up here too. Yeah. So let's say that you wanted to, let's say you were the plaintiff in our Spiky Club case, and you were, filing a summary judgment motion or whatever, some motion, and you want to say to the court, hey, Lovitz means that we can proceed with this claim as the plaintiff. And so what you would do is write a little paragraph at least about Lovitz, and first you would introduce how Lovitz fits into the context of our case. This is something that 1Ls do make a mistake on over and over and over and over again. They just start with some aspect of the case that doesn't introduce how it fits into the context of our case. So they might describe the precedent as, Lovitz is a case from Connecticut, or, Lovitz was decided by the trial court, or Lovitz was decided in 1923. I don't know what year it was, who cares? But Lovitz was decided, all these things maybe matter a little bit, but they don't explain how Lovitz fits in the context of our case. The fact that if you start out by just saying Lovitz was decided in 1923, that does not tell the reader why we should care about Lovitz, because 1,000 cases were decided in 1923. They don't all matter to our context. Okay? So introduce how Lovitz fits into the context of our particular case. Then state the facts, the holding, the reasoning. I'm a little bit less strict than the Judy Fisher supplement on what order you do facts, holding, reasoning, but I am fanatical on your introduction, your first sentence in introducing a case. If you're going to do a whole paragraph about a case, that first sentence needs to explain how the case fits in the context of our case. Lots of times, by the way, by the end of the year, you'll write a brief that mentions 10 cases, and you don't give each of those cases its own paragraph. You're going to weave the cases and the authorities. You spend more time on the important cases, less time on the less important cases. But I'm just talking about, if you're going to spend a paragraph on one case, do it this way, at least to the degree, do it this way by introducing how it fits in the context first. What does this actually look like? here's an example. This is the gay marriage case. In Obergefell v. Hodges, the Supreme Court held that the Fourth Amendment protects the right of same-sex couples to marry. So, presumably you're writing about this because we're dealing with, let's say that in our case, I was representing someone who wanted to marry a person of the same sex, and I'm saying to the court, hey, you have to allow this because Obergefell said so. So I write this first sentence. Then I go into the facts a little bit. In that case, several same-sex couples, child and marriage laws, these states, in holding that the 14th Amendment precludes such prohibitions, holding the court reasoning that marriage is too important to deny to anyone. So, introduce the context. Tell us why Obergefell matters. That's what we mean by introduce the context. Just tell us why this case matters, and then describe the case. I think as simple as Judy Fisher's 4 steps are, they actually overcomplicate it. Because there's really just 2 steps. Okay? Explain why this case matters, and then describe the case.
Can you email this to us?
It really is on page 31.
Oh,
Judy Fisher.
okay.
It's just a cut and paste job, I think. Yeah. With some simplification, but. All right. Obergefell. Nice. Okay, perfect. So we're now caught up. So let's do. You read Brian Garner, section 8. Elizabeth, remind us what Brian Garner's message is in section 8. It's about parallel phrasing.
Yeah, so I read that and I'm like, for me, when they're talking about when they number the pieces of a big paragraph, and all those pieces kind of go with the very first sentence, it's, I think, kind of imagine that you are going back to the very beginning of your paragraph with each number item and make sure that that sentence makes sense as you say it.
Yep, good. If you look on the page before that, you can see some good examples of parallel phrasing. The jury weighed the evidence carefully, skillfully, and wisely. The argument, carefully, skillfully, wisely, 3 adverbs parallel there. The arguments were long, disorganized, and unpersuasive. 3 adjectives. The facilities are available to doctors, officers, and corporate counsel. So you'd think this seems obvious, but he has examples of it not being so obvious. So if you look on the next page, this was the paragraph that Elizabeth was talking about, the first bad paragraph, and then it gets corrected later. Omega must show that Banerjee made a false statement that actually deceived on a subject about goods that resulted. It's confusing. Right? Made a false statement is a verb. Made is a verb. Right? That, not a verb. On, preposition. About, preposition. That, not a verb. Right? So, I think it's easier to actually just fix it. Look, practice this. So, in the 10 minutes we have, take a look at basic number, which one are we going to do here? Basic number 2, and fix the parallel phrasing, take the unparalleled phrasing and make it parallel.
The one that starts with tenant.
Yep.
This one right here.
Oh,
Starts with
yeah.
tenant.
Thanks, man. I was lost. Alright.
Oh, that was part of our homework. I already did it.
Oh, you did? Yeah.
I think we had that in the basic ones.
Uh-uh.
Oh.
Thank you, Zach.
Same thing.
So, let me tell this one. So don't overthink this.
It's not for you to.
You really just have to change. You really just have to change one word. Okay? It's not. This is not an exercise in like making it way more concise and way more clear. All you have to do here is fix the unparalleled phrasing, and there's only one thing to fix. And then today, I think the even you weren't here on Tuesday.
Oh, no, so it should be the same as it was.
So,
Even group.
unenforceable.
We only did one.
Do it.
Yeah.
I'll
So
wait.
the even groups will go to the board.
Okay,
so when I was talking about
Closure identifies the parties because
Identify.
it's like whenever things are in series, you want them all to sound the same. So it says like a description, the amount, the term, and then it should be like the
Nouns and
parties are
verbs.
identified or something.
Okay. I see what
You
you're
want
saying.
to keep them all like the same part of speech.
Yeah,
Not like just randomly throw a verb in there.
that makes sense.
now when it comes time for us to write,
So I think you would probably just say description of the premises, amount of rent to be paid, term of the lease, and the parties are identified or something.
Yeah, that sounds good. Or the identification of the parties.
Because most of them say like description of the amount of the term of, so you could say the parties of the lease.
Yeah.
They said this is for lease.
I don't have it. I think people have to. Basically, take the notes there.
Oh,
Bryce said,
yeah, I was wondering that. And you were here, I was like, dang, my voice is gone.
nah, I just got caught up. I'm driving all the way from Indiana, so.
Crap. I was trying to
Yeah,
print
you don't have to write the whole
for 10
thing.
minutes.
Or just
And
say
I never got it. Then she
say the
never
word you
finished
changed
on hers.
and what you would change it to.
And I've never been there.
Boom.
Points. Tenant will probably not be able, so let's first look at what's bad about it. Tenant will probably not be able to leave the lease, have the lease declared void and unenforceable for vagueness because it contains all the essential elements of a lease. A description of the premises, the amount of the rent to be paid, the term of the lease, and identifies the parties. Ouch, ouch, right? This is a list, and the list needs to have parallel structure. So what kind of list is it? It's a list of nouns until the end. A description, the amount, the term, identifies. All of those were nouns until you got to identifies, which is a verb. So the key is just to change identifies to a noun. You could do it multiple ways. You could say a description, the amount, the term, and the identities of the parties, or the identity of the parties, or you could just say, I think Group 6 had a good idea, you could just say the parties. So have all the essential elements of a lease, a description, the amount, the term, and the parties. Let's take a look at number 3. We won't like break out and do it, we'll just walk through it. The Younger Doctrine also applies to a state civil proceeding that is ongoing, implicates important state interests, and affords an adequate opportunity to raise federal claims. Anybody want to just volunteer, take a shot at what's wrong there? It's very minor. Yeah.
Implicates includes of verbs.
Yep. And is ongoing a verb?
Preposition.
It's not a verb. That's a good question. What is ongoing? It is ongoing. I think it would be an adjective.
Adverb.
Adjective.
Depends on, it can be an adjective or an adverb, depends on where it is.
Depends how it is. It is ongoing. Okay. I think it's an adjective, but I will confess, I'm not 100% sure.
It says that something is ongoing.
Yeah.
It's a predicate adjective.
So adjective. Okay, so we have adjective, verb, verb. We need to change it to verb, 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 and that's really easy to do. All you need to do is move where the parentheses 1 is, just move that to one word earlier, so that the sentence now reads, the Younger doctrine also applies to a state civil proceeding that, 1, is ongoing, is a verb, 2, implicates is a verb, 3, affords is a verb. Is, implicates, affords.
But we didn't change anything though, right?
We moved where the number 1 is.
Oh, okay. Is
We
that-
just
this is-
moved it earlier. Here, I'll show you. Oh, that's not it. Oh, that was the bad one. Okay. There we go.
Oh.
So, it used to be 1 ongoing, now it's 1 is ongoing. All right, I'll see you Wednesday.
All right, good day.